What happens in court-ordered child custody mediation? Hey there, my name is Ron Payne, and I'm an attorney and the CEO and managing partner here at Payne Law in Kernersville, North Carolina, where we help families navigate life's important decisions. And if you're talking about the custody of your children, I have 2 children myself. I know how just important these issues are to you because you want to make sure your babies are safe and protected. Whether they're 17-year-old babies or they're your 2-year-old babies, you want to make sure that they're cared and protected and safe at all times. Under North Carolina law, all custody cases have to go through mediation unless there's one of the exceptions, and I'll talk about those in just a minute. But almost all cases have to go through mediation. And if you're going to go through mediation, it's a little bit different than private mediation, which I made a separate video about. Private mediation is typically used either before litigation for child custody and support, or it's used for equitable distribution, alimony, spousal support voluntarily, and that's separate. So I'll try to link to that video here. But in the interim, if you're doing child custody mediation, it's mandatory, it's through the court, and it's a little bit of a different process. So I wanted to give you an overview. So the first thing that's going to happen is you're going to be ordered to attend custody mediation orientation. And what they're going to do is have you watch a video. Sometimes they've offered it via Zoom. Sometimes you have to physically go to the courthouse and sit in the room and watch the video. But you're going to get a notice to watch and complete this video or watch it. And then once you watch the video, you're going to meet with the mediator. In Forsyth County, the current mediator's name is Adam, but you're meet with whoever that is, and they're going to schedule a mediation for you. And when you watch the video, they're going to give you this overview. It'll be a lot like what this video is, but more in depth. But essentially, they're going to encourage you to try to settle a case. And even the judges will tell you, look, you can either have a stranger, the judge, who knows nothing about you other than whatever 30 minutes, 2-3 hours you're going to get to present your side of the case. They get there 2 or 3 hours to tell their side of the story, and that's it. So a total stranger is going to hear 6 hours of talk about your children, and they're going to believe half of what you say and half of what the other side says unless something goes crazy, and then they're going to make a decision. So in almost all cases, it is better if, and I say if, you can reach an agreement on your own that doesn't involve a judge. Now, if the other side is being unreasonable or continues to take actions no matter what they agree to that put the children in harm's way, then you have no choice but to go in front of a judge. But most of the time, emphasis on most, having a judge who doesn't know you or your kids make a decision about you and your kids is not ideal. But if you find yourself in that situation, we can help. So after you watch the video, Adam is going to set up a time to handle this mandatory mediation with you. They've encouraged you to mediate. They've encouraged you to participate in the process. The one downside I find about this mediation process in North Carolina is that it happens first thing. So oftentimes it's too early in the process. The wounds are still too raw for anybody to have a meaningful conversation about working out child custody because they're simply not ready to make compromises yet. But that being what it is, that is what the law requires. And so you'll watch the video, you'll meet with Adam, and then you'll set up a time to come back and actually conduct the mediation. And they typically schedule those in 2 to 3 hour blocks. So I think he does between 2 and 4 mediations a day. Certain days of the week, he's got to have a schedule that he'll give you. And once both of you have agreed on a date certain, then you come in and mediate. Now, unlike mediation where you do equitable distribution or these other issues where the lawyers will be present, whether either of you have a lawyer or neither of you have a lawyer, this mediation is unique. The only people who are going to be in the room with you for this mediation, for child custody, court-ordered mediation, are going to be you, the other party, and the mediator. So you say, well, but I need my lawyer. I hired you guys to go over the agreement. Don't worry about that. First off, the team at Payne Law, not every law firm does this, but one of the things that we try to do is we will meet with you, at least via telephone or via Zoom or in person, to go over what's going to happen during mediation and what we want you to focus on. Again, we're outcome focused. Court-ordered mediation especially is not a time to cast blame. Adam, 1, can't be compelled to testify in any future hearings, so it doesn't matter what the other side says. 2, it's not a time to give testimony. The why doesn't matter so much as the outcome. North Carolina starts at 50-50 custody. Adam and the mediators are going to encourage you strongly to go towards 50-50 unless there's compelling reasons. And these are all things we will prep you for going into the mediation because it's just going to be you. So you'll go in, we will help you put your best foot forward, work on achieving your goals if you are able to reach an agreement in mediation. Unfortunately, for court-ordered mediation in custody, it happens a lot less often. More often than not, it's just too soon and people aren't going to be able to settle the case. And that's okay. We're here for you. But if you do reach an agreement, that's fantastic. But don't worry, because what they're going to do is Adam is going to write that agreement up using his standard template. And when we get an agreement from Adam, he'll usually email and say the parties reached an agreement today. I will send a draft forthwith. And so when we get that draft proposed settlement agreement, one, that gives you time to sleep on it. In case maybe you feel like you got pressured into giving away the farm. We can look at that agreement and go, yeah, this is actually a pretty good agreement. It's probably what you're going to get in front of a judge. Or, yeah, I can see you gave away the farm. You shouldn't agree to this. I understand you weren't able to articulate your concerns effectively during the mediation. Don't worry. We're just going to decline to sign. It's not done until it's done, and done means signed, sealed, delivered to a judge, signed by the judge, clocked in by the clerk, and sent back. So if you get home and you're like, oh God, what did I just agree to? Don't worry about it. We'll be able to help you advocate for the changes that need to take place. And if we can't reach an agreement, then we'll let Adam know we've reached an impasse and move forward. So we will help you go over the agreement that Adam sends. He will tell you not to sign it without talking to your attorney first. And then we'll go from there. So we'll get the agreement. If you are not able to reach an agreement, then he'll send us an email. The parties were unable to reach an agreement. He cannot talk about anything you say to the judge, to the other party. Like he's out of it. Once you either reach an agreement or don't, his job there is finished. He'll either write it up or just let the court know. And his note to the court will say, the parties successfully completed mediation and were unable to reach an agreement. Period, the end. Finite. He cannot be compelled to testify about anything that was said. The reaching an impasse lets the court know that you've completed the mandatory requirements and you are now eligible to proceed for and calendar a hearing. Or that you've reached an agreement and here's the agreement and so let's get it signed, and then everybody goes home having saved thousands and thousands and thousands, if not tens of thousands of dollars on a child custody case if you're able to reach that agreement. Now, so a little bit earlier, I alluded to the fact that there are times when mediation can be skipped even though it's required. One, if one of the parties lives out of state. If you live more than a certain distance from the courthouse, the court can, not must, but may exempt you from mediation. Or they might just allow you to participate remotely, because typically it's done in person, but sometimes they'll allow remote participation depending on what it is and where you're going, that kind of thing. Secondly, if there's allegations of abuse, and that's typically going to be drug abuse, physical abuse, 50Bs, domestic violence, that kind of really heavy stuff, and therefore being in the physical presence of your abuser, or if you're the accused, being in the physical presence of your accuser, especially if there's any kind of pending criminal charges or 50Bs, then that would violate a court order, although the court can still order you to participate, but that is grounds for a waiver of that requirement. It's not automatic. If you are eligible to not complete mandatory mediation, you must ask the court to release you from the requirement for mediation. So you have to schedule a hearing, let the mediator know we are scheduling hearing to waive mediation, and then they will basically postpone conducting mediation and scheduling that until if and when the judge rules on your motion. Those are short motions. You're not going to get to put on your whole child custody evidence. The only thing they're going to hear in that hearing is, and oftentimes it can be done via, if for example, if you live in New York, but your kiddo is here and you file the petition for visitation and you just want to see your kid, the court would waive mediation for cause shown because you live in New York. They're not going to compel you to drive down from New York to participate. They might have the option, depending on your facts, of ordering you to participate via Zoom, but they're not going to order you to physically attend mediation in person because the statute allows for those who live more than a certain distance from the courthouse to be exempted from that, or the judge to give you conditions that make it easier for you to comply. So I hope this has been helpful. That's just a little overview of what court-ordered mediation is. If you want to see how it is different than the private mediation or equal mediation that you might do, an equal distribution or voluntary mediation to settle things, then check out my other video here on YouTube. Like and subscribe for more helpful, friendly legal tips. And until next time, please stay safe, take care of yourself, love on your families, be kind to one another, and have a great day. Thanks.